Good afternoon and welcome to the Queens County Family Court. On behalf of the Historical Society of the New York Courts, I would like to welcome you to our Constitution Day program. My name is Judge Philippe Solages, and I will be your moderator today. We are all gathered here in person and virtually to commemorate our founding document, the United States Constitution. It is a privilege and honor to moderate this program because we will be discussing two topics that many of us enjoy, history and the law, and both are extremely important. This is a historic day because this is the first time that the Historical Society has presented a Constitution Day program. Today, September 17th, marks Constitution Day throughout the United States. September 17th has significance because it is on this day in 1787 that the delegates to the Constitutional Convention signed the Constitution in Independence Hall in Philadelphia. Constitution Day was legally established by Congress in 2004. The Constitution provides the framework for the United States government. The United States Constitution plays an integral role in all our daily lives. For example, the post office is mandated by the Constitution. The census has its roots in the Constitution. Two areas of law, intellectual property and bankruptcy, are found within the text of the Constitution. I'm holding up a copy of the United States Constitution. Our founding document is over 230 years old. It was drafted over the course of nearly 4 months during the summer of 1787. The preamble of the Constitution begins with 3 words: we the people. It is organized into 3 parts: the preamble, the articles, there are 7 articles, and the amendments. There are 27 amendments. The first 10 are known as the Bill of Rights. New York ratified the Constitution on July 26, 1788. It was the 11th state to do so. The Constitution contains 39 signatures. One of the signers of the Constitution was Rufus King. Rufus King was a founding father. Rufus King was a lawyer. Rufus King was a United States Senator from New York. Rufus King's homestead, the Rufus King Manor, is still in existence today. It's a working museum. In fact, it's located directly across the street from this courthouse. That is why we chose to hold this program at this perfect venue. Before we formally begin the program, there are a few housekeeping matters that I need to address. First, 1 CLE credit will be awarded for this program. I will mention the CLE code during the program, so please pay careful attention. Second, I would like to take the time to acknowledge Chief Judge Rowan Wilson for his leadership. And we are in Queens now, so I would be remiss if I didn't acknowledge Chief Administrative Judge Joseph Zayas. Now, as the title of this program indicates, we are here to have a robust discussion about the Constitution. To do so, we will be joined by two distinguished individuals from the legal profession. First, Judge Edwina Richardson will provide us with opening remarks. Judge Richardson is the Deputy Chief Administrative Judge of Justice Initiatives. However, in our court system, she's known as the Titan of Justice. Under her tutelage, Judge Richardson is tasked with ensuring meaningful access to justice for those appearing in all New York State courts, regardless of income, background, or ability. She began her career in the court system right here in the Queens County Family Court. She is right back where she started. Additionally, we will be joined by law professor Tyler Rose Clemons. Professor Clemons is an assistant professor of law at St. John's University School of Law, where she teaches evidence and constitutional law. She writes about the interactions between the law and the lived experiences of marginalized people. Professor Clemons was born and raised in Mississippi and has lived in New York City since 2021. The professor will be leading our discussion today. It gives me great pleasure to pass the baton to Judge Richardson for her opening remarks.
Good afternoon, everyone. Good afternoon. You can do better than that. Good afternoon, everyone.
Good afternoon.
Happy Constitution Day.
Same to you.
Woo-hoo. All righty. So I have some opening remarks for you. Consider me the appetizer and the dessert for today's program. This is the appetizer portion. The meal will be provided, the main course of the meal will be provided by my colleagues. So first, I thank the judge for his generous introduction. I'm really, really delighted to be here with you today as we celebrate Constitution Day. And I'd like to offer thanks to the Historical Society of the New York Courts, the King Manor, the Queens County Family Court, and I honor its supervising Judge Gilbert Taylor, who is present here today. Thank you for making your home our home for today's program, and everyone involved in organizing this event. So, Constitution Day is an opportunity for us, an opportunity to engage in a reflective process, to think about the Constitution's beginnings, its principles, and how it has changed over time. It provides us with the opportunity to contemplate what this important document means for us today and how it can guide us in the future. As has been mentioned, it was signed 237 years ago today and ratified in 1788, a year later. It is, I'm told, the oldest constitution that is still in effect. I don't want to leave you in suspense. Number 2 is Norway and number 3 is Belgium. But not only is our Constitution notable for being the oldest Constitution still in effect, but it is also among the shortest in terms of the number of words in this document. I am told again, I didn't count, that this document, the Constitution, including its amendments, have 7,591 words. Why do I talk about its brevity? Because to me, the person for the court system that leads access to justice, to make the courts available to all in our community, this is access. Our Constitution is accessible. It is available to us. It is not a reference book, and I'm talking to the students in the front row now. It's not just a reference book in a library to gather dust. In many ways, not only is it available and accessible, it's a living document, as I'm sure my colleagues will discuss. And because it is available, I've decided to have a new yearly habit on the Constitution's birthday to read it again and again each year. Anyone going to join me in that new habit? Okay. If you make a promise, you have to keep it, because I'm a judge. So a promise is a court order and it has to be obeyed. So the preamble of the Constitution, the beginning, the first three words were mentioned already, and I'm going to read it from my pocket Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The preamble announces our nation's core values and ideals: democratic government, justice, and liberty, all with the goal of forming a more perfect union. Think about that phrase, a more perfect union. That tells me that the framers were very much aware that it was a union and a document that could be and needed to be improved upon so it could be more perfect. I appreciate that it acknowledges itself and acknowledges our nation as both aspirational and imperfect. The preamble reminds us that we have something to strive towards, that we cannot be complacent. It reminds us that society is dynamic. Justice Ruth Bader Ginsburg has noted that the Constitution and the Union, and this is a quote, very much need perfection. The preamble is a call to action. While the Constitution claimed to be for the people of the United States and did espouse the virtues of liberty and justice, think about the lived reality of 18th century America. It contradicts these very ideals. Consider who got to be the we in we the people. I'm looking around this room and I will guess that it did not include 90% of us in the we of we the people. Most who were living in America at the time it was signed were excluded from its protections. Only white property-owning men could vote. The Constitution expressly describes certain categories of humans to include, and this is a quote, free persons. So if there are free persons, that means there are other persons who are not free. And those in indentured servitude were specifically referenced. And the Constitution implied and presumed the ugly institution of slavery. The Constitution we discuss today, at its inception, considered, calculated, and counted all other persons, which means the enslaved Africans, as 3/5 of a person for House of Representation, House of Representatives, and taxation apportionment purposes. Let's look at this flyer for this program. I'm so glad that someone was nice enough to hand me a flyer. Does everybody have a flyer? Take a look. Oh man, I'm still not used to anybody other than my mother being called Mary, but I'll take it. Let's look at this flyer. Take a look at the pictures of the people. These were the people. These were the we, and we the people. And I believe this flyer was properly selected by our host today as an accurate description of the Constitution's origin story. But that's not the full story. It's the origin story. I originally was going to say well over half of us in this room and in our live stream audience, I would guess, are not reflected in that picture, but I think it's closer to over 90% of us would not be in the we the people. Those gentlemen most certainly would not have envisioned a world where the justice that they would promote and proclaim in this document would be championed by someone who looks like me. So, I am the appetizer, and there is so much in this Constitution and its amendments I wanted to chat with you about today, but I'm going to stay in my lane and only talk a little bit about some of what I'll call my favorite amendments. Am I allowed to have favorite amendments? Well, I'll say they are among my favorite amendments. How's that? But it's in line with my role leading our court system's equal justice and anti-bias law, which I'm responsible for making the courts as fair as they can be for everyone and anyone who enters or serves in our courts. So I'm eager to touch upon the 13th, 14th, and 15th Amendments, collectively known as the Reconstruction or Civil War Amendments, because they were enacted in the Reconstruction era between 1865 and 1870, following the American Civil War. These amendments provided an opportunity to shatter racial barriers, launching what was considered a new dawn for the United States. It has been referred to, because it is so profound what these amendments were geared to doing, as a second founding of this country. The 13th Amendment prohibits slavery, footnote, except as punishment for a crime. So many of us in this room may believe that going towards a more perfect union may need to address that exception. The 14th Amendment provides that all persons born or naturalized in the United States are citizens and promises fair and equal treatment, that no state shall deprive any person of life, liberty, or property without due process of law, or deny any person equal protection of the laws. So before the 14th Amendment, the Constitution really lacked any definition of citizenship at all, and allowed states to figure that out, as well as figuring out a lot about slavery. The Supreme Court infamously held in a decision I hope you're familiar with, the 1857 Dred Scott versus Sanford decision, and I'm going to quote directly from that decision: "A free Negro of the African race whose ancestors were brought to this country and sold as slaves is not a citizen within the meaning of the Constitution of the United States and could not expect any protection from the federal government or the courts." In that decision, Justice Taney noted that there were two references in the Constitution. If you do what I asked you to, or ordered you to, and read your Constitution, you will see these two references yourself. References to, quote unquote, this race in the Constitution treats them as persons whom it was morally lawful to deal in as articles of property and to hold as slaves. Indeed, and I'm further quoting because there's nothing more powerful than the actual words, the Constitution of the United States recognizes slaves as property and pledges the federal government to protect that property. And we have the 15th Amendment to the Constitution, which prohibits abridging the right to vote based on race, color, or previous condition of servitude. So that meant, as I mentioned, prior to the 15th Amendment, only white men who owned property were permitted to vote, having that as a right. And with this amendment, in theory and in law, black men could join them as well. So these Reconstruction amendments that I am excited about injected into the Constitution for the first time an ideal of equality in a much more broadly inclusive way than ever before. Despite the clear and lingering imperfections, such as limiting suffrage to males, these amendments were novel, they were radical at the time. It is our national collective shame that the amendments did not meet their promise. They did not result in immediate or lasting access to justice for the formerly enslaved. We had black codes, we had Jim Crow laws, and acts of systemic infliction of terror in the form of white nationalism of the time, ignored and sanctioned lynchings, along with Supreme Court-approved state-sanctioned racial segregation. All of that combined prevented the realization of the ideals of this living document that we are discussing today. Perhaps the most famous and illustrative example of how the change that these amendments could bring about could not be realized until decades after implementation is Brown versus Board of Education, another important U.S. Supreme Court decision overturning Plessy versus Ferguson as a violation of the Equal Protection Clause and that 14th Amendment that I love so much about separate being equal. Supreme Court Justice Ketanji Jackson Brown, he's got an autobiography. I'm only up to the yellow page, but I've read enough for it to help me with this presentation. Her autobiography, Lovely One, beautifully describes her personal family history pre and post separate but equal life. So the things we're discussing today are relevant for today. And I hope that you listen with that open mind and open heart, and with the thought of how this applies to our lives. Since its enactment, the 14th Amendment has been used to protect and promote civil liberties well beyond race. Well beyond race-based discrimination. The 14th Amendment has accommodated, as Justice Ruth Bader Ginsburg, who I mentioned previously, when she was a practicing attorney and law professor, quite successfully relied on this very same equal protection clause to combat discrimination based on sex. And more recently, we have the U.S. Supreme Court holding that we cannot deny same-sex couples the right to marry under that same due process and equal protection clauses, the Constitution as a living document. So we're coming to the end of the appetizer, and I'm going to turn it over momentarily, just with the reminder that the shift that came with what I'm a fan of the Reconstruction Amendments, and I talk about it. We are still in a time, right now, in need, in my opinion, of reconstruction. There are some critical steps I believe our nation needs to make as we go along this journey of a more perfect union. Progress has not been steady. We go forwards, we go backwards, we go forwards again, but we keep moving. It's hard to keep my glass three-quarters full mentality, which I tend to have, because right now I believe that we are in a season of deeply concerning constitutional setbacks. And I trust in the power of the law. I trust in the power and the promise of America. I trust in the availability of our Constitution and its ideals of liberty, justice, and a democratic society. So I'm going to come back to give you dessert when I close out today. I'm going to now turn this program over. And with the thanks, I'm thanking you in advance. Look what you let me do. Do you see how excited I am? Students, do you see how excited I am? I love the law. I love the law. The law is fun. It's available to us. So you gave me the chance to do something I love, to grapple with this, to think about it very, very deeply. And I don't get to do that every day. So I'm going to now turn it over to Judge Solages and Professor Clemons to hear what they have to share with us as we continue on our quest for a more perfect union.
Thank you so much, Judge Richardson, for those inspiring words. Thank you, Professor Clemons, for joining us.
It's my pleasure. Thank you all so much for having me.
We have a lot of ground to cover in a short amount of time. So let's start from the beginning. What motivated the framers of the Constitution to convene in Philadelphia?
Yeah, so with what Judge Richardson just said, I'm being told to talk into the mic, so I'm going to move it over here. Is that better? Okay, so Judge Richardson just beautifully pointed out that the Constitution continues to have real impacts on real people's lives today. But it's important to remember that it is a historical document that was designed to address historical problems in the 1780s when it was convened. So when most people think about the Constitution, right, they think we went immediately from the American Revolution into the constitutional era, and that actually is not what happened. The Constitution has a predecessor called the Articles of Confederation that was the first attempt to create a national government of the newly formed United States. And within the 1780s, the consensus became that it had largely failed. It was a much weaker federal government than the one created by the U.S. Constitution. It had a few notable flaws. The first was that it had a lack of executive power. So the Articles created a Confederation Congress that had the power to pass laws, but it didn't have any kind of power to enforce those laws. It didn't have a military of its own. It just would pass the laws, and then the states would comply with them or not comply with them as they saw fit, and you can guess how often they saw fit. The other problem was that it didn't have any judicial power. All of the courts at the time were state courts, and so the Confederation Congress would pass a law, and then questions would arise about how that law would apply in certain situations. That would go into state courts that were inherently biased towards their state and against other states in the Confederation Congress. And so things were getting skewed that way, and there wasn't anything the Confederation government could do. The last big problem was that it didn't have any taxing power. And we all know that money makes the world go round. the Confederation Congress had to requisition, it had to ask the states for money. And then again, the states would either choose to send them the money or not send the money as they saw fit. You can guess how often the state said, oh yeah, sure, here, you can have some of our money. Not very often. The problem was it was incredibly difficult to change any of those things. So under the Articles, every state had the same representation in the Confederation Congress. Everybody got one vote, no matter how big or small the state was. And amendments to the Articles had to be adopted unanimously. And while everybody agreed that some or all of these problems were real, everybody benefited from each of them at least once. And so the numerous attempts that got made in the 1780s to change the Articles failed because there was always a holdout. Somebody always said, no, we like things the way they are. We're not going to allow you to change the Articles. So that's the government that's going on at the time in the new nation. At the same time, you had what some people have described as the worst economic crisis in the United States until the Great Depression. So wars cost money. The United States had fought the most powerful empire in the world and won by the skin of their teeth. That was expensive. You had to pay troops, you had to pay for supplies. The U.S. owed collectively about $75 million in 1783 money, which is almost $2 billion in today's money in post-war debts. And so that was creating an economic crisis in the colonies. And then part of what the states had promised Great Britain is that the debts that existed before the war would also be paid by the new nation. So the states started getting creative about how to deal with this problem. And they started passing a variety of debtor relief legislation. One of the most creative ways at the time, which doesn't feel very creative as today, was paper money, right? At the time, all money was actual gold and silver that you would use to pay for things on the street. The states began passing paper money and saying, oh, well, this amount of paper money counts as that amount of gold, and so therefore trying to get around the debt that way. Some states, like Rhode Island, just flat out said, these debts are liquidated, you don't have to pay these anymore. And it was creating a real crunch. One state in particular that refused to do that kind of thing was Massachusetts. And a group of mostly veterans of the Revolutionary War, led by Daniel Shays in 1787, decided that they had had enough, that they wanted the debt relief that the other states had gotten. So they led a march on the Federal Arsenal in Boston, and the state of Massachusetts had quite a bit of trouble in gathering enough troops and gathering enough money to put that rebellion down. And Shays' rebellion really just crystallized everything that was wrong with the Confederation government and its complete inability to deal with the crisis of the new nation that had formed in the 1780s. And so a convention had met in 1786 in Annapolis, in Maryland, to try to change the Articles. They had convened with a resolution to convene another convention in Philadelphia in May of 1787. And so the convention in Philadelphia convened with the ostensible goal of changing the Articles, but by that time, a number of the people attending that convention, most prominent among them James Madison, had decided that something much more radical was going to happen and that we were going to form a completely new system of federal government. And so that's what led to the Philadelphia Constitution.
Understood. What fundamental principles did the framers want to incorporate into the Constitution?
So we know the principles that they were thinking about because they left us a pretty detailed record, both of the convention itself and of the Federalist Papers, which were a series of essays, 85 of them, in fact, that were addressed to the people of New York, written by Publius, which was a pseudonym, meaning public one, but were really written by James Madison and Alexander Hamilton and John Jay. And they laid out basically their vision of what the Constitution was supposed to be and the fixes that it was going to make to the system of the Articles. So, these days everybody has influencers. You got influencers on TikTok and Instagram. Well, the framers had their own influencers. They didn't have Instagram, but they did have books. They did have documents. And one of those influencers at the time was a Frenchman by the name of Charles de Montesquieu, who published a book called The Spirit of the Laws in 1745. And from that book, the framers took this idea of the separation of powers. So the idea was that concentrating different types of power within one person or one body of people is what led to tyranny and oppression. So Montesquieu divided power up three ways: the executive power, power to enforce the laws; the legislative power, the power to make the laws; and the judiciary, the power to interpret the laws. They sound familiar now, but it was novel at the time, right? And his idea, Montesquieu's idea, was to split those up among the government so that the people who were making the laws were not the ones interpreting them and enforcing them. And so that's one of the ideas that goes in and becomes Article 1, the legislature, Congress; Article 2, the executive, the presidency; Article 3, the judiciary, the Supreme Court; and then eventually the lower federal courts. So that's one idea. Another one of those influencers was John Locke, who was an English political philosopher. His most popular work at the time was his two treatises on government, which were published in 1689. And from Locke, the framers took this idea of limited government and popular sovereignty. So the idea, as Judge Richardson said, that it is we the people who actually have political power, and that we are the ones that give consent to the government to regulate our lives, and that we have certain rights that those governments cannot impinge upon without doing something first, right? Without giving us due process of law. And so that's Locke. And of course, Locke is entirely in the Declaration of Independence, right? It's Locke all the way down. Less explicitly so in the Constitution, but those ideas are still there. The final influencer was a man named William Blackstone, who wrote the commentaries on the laws of England. Of course, the new colonies had been English, were British, still considered themselves to be in the Anglo-American legal tradition. And Blackstone had taken all of this English common law that had been developing and written this commentary that collected all of it. And from Blackstone, the framers took the idea of due process, that there are things that the government has to do, procedures that the government has to go through before they can take away someone's life or liberty or property, and what those actually might be based on the tradition and what the government has done in the past. The final kind of idea, and this I think is the framers' big innovation, is federalism. This idea that in addition to splitting power among the three branches, we are going to split it between the state governments, which already exist, and the federal government. And there are going to be things that the federal government is going to do exclusively and things that the state governments are going to have the power to do exclusively. That, I think, was the first of its kind in the world. There were systems that existed similar to that before, but certainly no system where it was consensual on both sides, right? Like the states were giving up some of their power and the federal government was conceding that thing. So it was this idea of how can we constrain government so that we don't have oppression, but we also can have effective government that is able to deal with these economic crises that are plaguing the nation.
Thank you. I remember my days from law school studying criminal law, and William Blackstone had a very famous quote: "The law would rather let 10 guilty people free than to let one innocent person suffer."
Yeah, absolutely. And that idea comes straight out of the English common law tradition. Shout out to my evidence students who are watching. We talked about that quote earlier in the semester, right? And that idea gets imported directly into the Bill of Rights and the due process that we allow criminal defendants to have in this country.
You mentioned the Federalist Papers, and I'd like to talk about Federalist 78. It's one of the most cited of the Federalist Papers by the United States Supreme Court. Can you please elaborate on that?
Yeah, sure. So Federalist 78 is where Alexander Hamilton, who was the one of the three who happened to write that one, is talking about the judicial power. So one of the issues that we find in a constitution like ours is that it is short. And as Judge Richardson said, that's a good thing, But that also means that it doesn't provide a lot of detail in specific circumstances, right? So when we say that the government can't take your life, liberty, or property without due process of law, what does that mean? What is property? Does that just mean I can't come take your land, Wild West style? Or does that also mean that the government can't take, your pencil, right? Is that property? What is due process? Do I have to give you a hearing? Do I have to give you an attorney? What does that mean? So the judicial power is about who answers those questions. And in Federalist 78, Hamilton is saying that it is the judicial power vested in the Supreme Court of the United States and eventually the lower federal courts that are going to have the primary authority of actually interpreting those words within specific circumstances. And so it sets up this idea that we call judicial review. That eventually gets adopted, although not explicitly in the Constitution, just a few years later in Marbury versus Madison in the early 1800s, where the Supreme Court itself, under Chief Justice John Marshall, adopts this idea and says that famously, it is unquestionably the province of the judiciary to say what the law is. And in that decision, for the first time, the Supreme Court struck down part of an act of Congress that it thought conflicted with the Constitution. It established the right of the court to do that. It did not do that a lot in the first 60, 70 years of its history. In fact, Marbury was the only time until the decision mentioned by Judge Richardson, Dred Scott versus Sanford in 1857, where the court struck down another act of Congress. It became much more active in striking down laws as violating the Constitution after the Reconstruction Amendments, and certainly during the modern era, we hear about the court striking down various state and federal laws all the time. But Federalist 78 was kind of the genesis of those ideas that the court would have the power to do that.
You mentioned Alexander Hamilton. Before Alexander Hamilton became a star on Broadway, he was actually a New York lawyer, and he actually was one of the first lawyers on record to be involved in a murder case, the People versus Levy Weeks case. And that case, the Historical Society on its website has some valuable information about that case. So a lot of New York lawyers, including John Jay, have had a lot of significance in our history. Even Mount Rushmore is named after a New York lawyer. So I want to pivot.
And featuring a famous New Yorker, Franklin Roosevelt.
Yes. So I want to pivot, and I want to talk about some of the controversial issues that came up during the Constitutional Convention.
So when we talk about the framers today, we have this tendency to refer to them as a collective, right? The framers, what the framers thought. The framers thought a whole bunch of different things, and they argued nonstop, including after the document was signed, right? So as I alluded to earlier, James Madison came into Philadelphia with this idea of what he thought the new government should look like. They called it the Virginia Plan because James Madison was from Virginia. And one of the hallmarks of that was that Madison was going to have it so that the two houses of Congress, the Senate and the House of Representatives, were both apportioned according to population. So remember that I said that in the Confederation Congress, everybody had an equal vote? Well, that felt very unfair, because some states, like Connecticut and Rhode Island, were tiny, both in land size and population, and some states, like Virginia and New York, were massive. And so someone's vote in one of the small states felt like it counted for so much more than someone in the large states, and those states should have a proportionate share of the power. So Madison comes in with that plan that they're both going to be apportioned, and of course the small states throw a fit, because they would be losing a ton of power. And that was one of the central issues of the convention, is how the legislature was going to be apportioned and whether it was going to be by population. That winds up resulting in what we call the Connecticut Compromise, because it was proposed by the Connecticut delegations. And what we decide is, what the framers settled on, is that the Senate is going to be equal representation. So every state now has 2 senators, no matter the population size. The House is going to be apportioned by population, so that one house gets population, the other house, it gets equal. It was a compromise that the larger states agreed to because they wanted the Constitution to go through, and the small states basically said, no, we're going to hold up the whole thing unless you give us this. This gave James Madison heartburn until the day he died. He was not happy with this compromise, but it was one of the things that winds up going through. By the way, the Electoral College also comes out of this apportionment compromise because the framers anticipated that Congress would have a much larger role in presidential elections than they have historically. And the larger states weren't willing to just give over completely the presidential election to the smaller states. And so the Electoral College has proven controversial, especially recently, and that's part of the reason why it exists, is it's a holdover from this apportionment issue. The other big issue at the convention is one that Judge Richardson has already alluded to, and that was the problem of chattel slavery. I want to say before I talk about this issue, oftentimes when we talk about this issue, we talk about free states versus slave states. There were no really free states in 1787. Massachusetts was the only state at the time where slavery was illegal, and it had just become so in 1783. All the other states permitted chattel slavery within their borders. It was just a matter of what percentage of their wealth and population actually constituted enslaved people. So it's less than free states and states that were majorly involved in the slave trade. So keep that in mind. One of the big issues around slavery was whether we were going to ban the federal slave trade. So could merchants go over to Africa and abduct people from the tribes and nations of Africa, bring them back to the United States, and have them as slaves? By the 1780s, a number of people had become morally opposed to the slave trade because it was just so incredibly brutal and dehumanizing. Ironically, a number of the older slave states themselves also wanted to ban the importation of slaves because they already had sizable slave populations in their states, and preventing the newer slave states from importing new slaves would have increased the value of the slaves they already had, and so they could make money that way, right? So it was this weird sort of dynamic going on around this really horrible thing. The compromise that winds up coming out of there is that there's a clause that says that Congress cannot ban the international slave trade until 1808. Which was roughly 20 years after ratification. Congress immediately did so in 1808, though of course the institution of chattel slavery continued until the Civil War. Another major part of the slavery controversy resulted in what we call the Fugitive Slave Clause, by which free states were prevented from interfering with slave states' rights to re-kidnap enslaved black people who had escaped into their borders, and it pledged the federal government to help them. Now, this often gets confused with the Fugitive Slave Acts, which get passed in 1793 and 1850 and required free states to actually affirmatively help with the re-kidnapping of enslaved black people, but it's in the Constitution itself that those states can't interfere with the recapture. By the way, historical footnote, the Fugitive Slave Clause has actually never been repealed. It is null and void because of the 13th Amendment, which outlawed slavery with the important footnote, but it is still part of the Constitution, the text of the Constitution itself. So, it's still there. The final and probably thing that people know about the most part of the sort of slavery issue at the convention was what resulted in what we call the 3/5 compromise. So a sizable percentage of the slave states, mostly southern states, actually were enslaved black people. And the states where those people were wanted those people to count as whole persons in determining how many representatives in Congress, in the House, those states were going to get. They did not want them to count at all as property for the purposes of determining the tax base of what Congress was going to be able to get from them in terms of the wealth. So slave states wanted all person, no property, which is kind of ironic, but that's what they wanted. The free states wanted the reverse, right? They said, this is your property, this is your wealth, we get to tax this enslaved population, but they're not actually represented. They don't have any kind of political rights, so they shouldn't count for representation. So they wanted all property, no person. The 3/5 clause is the compromise for that, right? So we wind up saying that enslaved black people are going to count as 3/5 for both the tax purposes and representation purposes. It's been pointed out by many others, and I think it bears saying here, that it is a misstatement to say that the 3/5 clause meant that enslaved black people counted as 3/5 of a person, because none of that value that they generated went to the enslaved person themselves. It was entirely either to the federal government for tax purposes or to the states that their owners belonged to for representation purposes. And it actually wound up giving the southern states a considerable bump and political advantage in representation that was controversial until the Civil War eventually eliminated it.
The word slavery does not appear anywhere within the text of the original Constitution. The word slavery first appears in the 13th Amendment. And the founding fathers knew that it was wrong, and they did not want to sully the Constitution. So that's why it doesn't appear there. It's made reference to, and it's implied.
Yeah.
So you mentioned judicial review, the concept of judicial review. How did the justices of the Supreme Court become the primary interpreters of the Constitution?
Yeah, so it's really that Marbury versus Madison decision, right, in the early 1800s, where the court gives itself the authority, although maybe with the backing of Alexander Hamilton and the Federalists, to declare laws of Congress and eventually of the states unconstitutional. And that was one of the crucial innovations of the American Constitution, this idea that the Constitution is the supreme law of the land, and laws that violate the text of the Constitution, whether they're state laws or federal laws, are actually illegal. Because if they violate the supreme law of the land, they are not themselves lawful. That was a new idea at the time. And it was one that the framers had dealt with in fighting against Parliament in England. Because the parliamentary idea, the English tradition, was that if Parliament passed the law, it was not illegal. And the English Bill of Rights, which happened about a century before the American one, it was basically about the rights of the people to elect their representatives in Parliament. The American Constitution was really the first time that it was contemplated that the people's representatives, the legislative power, could pass a law that was still illegal, because it violated the Constitution, because it violated an individual right.
Let's pivot and discuss some contemporary issues. How has the Constitution changed since ratification?
Yeah, so I think it is important to make the point that Judge Richardson did. So every constitutional republic in the world, other than the United States, has gone through multiple iterations of its constitution since 1787. So this is a story of change, but it's also a story of remarkable continuity. The first big change was the Bill of Rights, which, as I alluded to earlier, was a point of contention at the Constitutional Convention itself. Madison, even though he was originally opposed to the Bill of Rights himself, wound up going to Congress, getting them to pass it and enact these first 10 rights, and sets up the Constitution as this document not just about process, not just about the delegation of power, but also about protecting individual rights and individual citizens against the Congress. The second big pivot, which I'll touch on briefly because Judge Richardson did it so eloquently, was the Reconstruction Amendments, right? And what I will add to what she said is that after the Civil War, so originally the Bill of Rights just applied to the federal government. So it was just Congress and the federal government that could not abridge the freedom of speech, so on and so forth. the Civil War was this constitutional moment where the Reconstruction Congress basically said, states, we can no longer trust you to protect your own citizens in these ways that we deem fundamental. Because through the institution of chattel slavery, you have demonstrated that you are not going to do that. And so it dramatically alters the federal-state balance that got set up under the original Constitution to give the federal government the authority to step in between state governments and their citizens to protect the rights of those citizens against the states themselves. And then there's been lots of other changes, but the other one I want to highlight was the Court of Chief Justice Earl Warren, sometimes called the Second Reconstruction, that resulted in the Brown versus Board of Education decision that Judge Richardson mentioned, picking up those ideas of equality that get introduced in the Reconstruction Amendments and actually giving them force and life. And then also doing the same thing with individual rights, like in Miranda versus Arizona. So if you've watched Law and Order or CSI, you know that you have the right to remain silent, you have the right to so on and so forth, right? So it's Miranda that says that the police, that law enforcement have to read you those rights. And so I think we're still in the process of processing what the decisions of the Warren Court mean and whether we want to take that moving forward or whether we want to dial some of that back.
You just talked about the debate between the Federalists and the Anti-Federalists. How do fundamental constitutional principles shape the current debates about the Constitution?
Yeah, so it's tricky, right? Because the world of the 1780s, it was radically different. I mean, we're talking about a time period where people were still literally driving around in horses and buggies, and information took that long to travel as well. So how do we take those concepts and principles, things that the framers would have, and apply them to things that the framers would have never even imagined or comprehended, like telephones or vehicles or the internet, right? And a lot of that happens by reasoning by analogy and thinking about how the framers would have thought about these things based on how they thought about similar things. So one case from the most recent term, Moody versus Net Choice, dealt with social media companies. So Texas and Florida have passed these laws that try to impact how companies like Facebook, Instagram, TikTok moderate the content on there. And so Justice Kagan wrote the opinion for the court, and in it you see her drawing these comparisons to things that the framers would have understood, right? So she's like, Facebook is kind of like a newspaper publisher or a book publisher, and so therefore, because the states can't do this with a book publisher, they can't do this with the social media, you know, like that kind of reasoning. I think that the problem that the court is going to face increasingly is, when do things become so different that the analogies don't work anymore? And when do things become so different that analogizing that way actually creates more harm than it does good? So that it no longer fits the world that we live in. And I don't think that that has happened yet, but I can see it on the horizon with things like generative AI and other things that, you know, the court doesn't even understand because they're lawyers, they're not technology people. But also, they fall so far out of the world that the framers would have known and addressed.
I'd like to take the final minutes to discuss an interesting topic. There's always a lot of emphasis on the U.S. Constitution. Let's talk about state constitutions briefly.
Yeah, sure. So there are 50 state constitutions. Every state has one. The U.S. territories, Puerto Rico, Guam, the Virgin Islands, Northern Mariana Islands, also have their own constitutions, and they tend to be much longer, and they also tend to be updated much more frequently. So the current version of the New York Constitution as a whole was adopted in 1939. It was last amended in 2018, which you may not have even realized happened, but those are the kinds of things, because states have what we call general police power, right? States can actually enact legislation on basically any topic. Those constitutions tend to be longer and much more difficult, and a number of lawyers are paying much more attention to state constitutions these days as ways to vindicate individual rights, as the U.S. Supreme Court signals that it may be less receptive to those kinds of claims under the federal constitution.
So state constitutions tend to afford their residents more protections than the U.S. Constitution?
I mean, it varies by state, right? New York's constitution is very protective. My home state of Mississippi's is the only one without an equal protection clause, which, you know, it might say something. So it depends on the state, but it can be, and it often is, and it certainly is in New York.
Understood. Thank you. Do you have any parting words for the audience?
Yeah, you know, I just want to echo Judge Richardson's point about the fact that the Constitution is first and foremost a document that does belong to we the people. It doesn't belong to the Supreme Court. It doesn't belong to the president. It belongs to us. And we have the privilege of living under the rights that it gives us, but we also have the responsibility to make sure that our voices are heard and that we play an active role in protecting the rights that we believe that we deserve and that we want our children to have. So you being here today is part of that process. And I encourage you to continue to think about these things and talk about these things with yourselves, with your friends, on your social media accounts as we move forward.
Thank you. We will now hear closing remarks from Judge Richardson.
Let's give them a round of applause. Very, very well done. Judge and Professor, thank you so much for this informative discussion. I am going to close by sharing a quote from President Barack Obama. He gave a speech entitled A More Perfect Union. And in that speech, he said that each generation is tasked with narrowing the gap between the promise of our ideals and the reality of their time. And I believe that that was the message that we were trying to set and send to you today. As judges, lawyers, a lot of lawyers in the room, legal system professionals, and most importantly to the young people, students, it belongs to all of us to do what is ours, to uphold and make real that more perfect union that we've been talking about today. And discerning what this Constitution means for us 237 years after its signing. And just as the Constitution has evolved, in my opinion, with steps forwards, backwards, and we have to go forwards again, the New York State court system, we have our own mission statement, and we have evolved as a court system in a similar way. The base of our mission statement for the courts, the one that has existed for years and years and years for New York State, reads as follows. The mission of the unified court system is to deliver equal justice under the law and to achieve the just, fair, and timely resolution of all matters that come before our court. And importantly, like my Constitution, it, as I stated, has also evolved to add this part. This is new. This was created over the course of the last few years, and it was created and established with some we, the people, we, the real people of today in the courts, adding to our mission statement this way. In the service of our mission, the unified court system is committed to operating with integrity and transparency and to ensuring that all who enter or serve in our courts are treated with respect, dignity, and professionalism. We affirm our responsibility to promote a court system free from any and all forms of bias and discrimination, and to promote a judiciary and a workforce that reflects the rich diversity of New York State. So this court system's mission, as well as the portfolio of my ever-expanding office, the Office for Justice Initiatives, reflect and actualize many of the principles that we're talking about today. Equal protection, due process, access to justice. And like our Constitution, that mission of the courts is aspirational. Making our mission statement a reality is a shared responsibility and requires all of us, and all means all, the legal professionals, the judges, the students, the community members, all of us, to work and do what is ours to do to move us towards that more perfect union. And we're taking a step today, celebrating Constitution Day in this way, reflecting on our past, moving towards the future that our children and their children deserve. So I'm happy and grateful and gratified that you allowed me to be here to greet you today. I do have one other thing I want to say before I let you go. We have today just announced in the court system, because I've got students in the room, for high school students, an essay contest regarding Constitution Day. There is a woman in the room who's going to stand up right now. Her name is Zenith Taylor. She's our newly appointed, our chief judge created a position, newly appointed civic engagement coordinator for the state of New York. It's my pleasure that she gets to work in my ever-expanding Office for Justice Initiatives. And she's our statewide civic engagement coordinator. She'll be here to talk to you about that essay contest, all right? So, perfection towards a more perfect union. Perfection is not possible. No one, no thing is perfect. But as we aspire and strive towards that perfection, we will be the best we can be and what we deserve to be. So thank you. Happy Constitution Day, everyone.
I would like to take the time, thank you so much for those parting words. I'd like to take the time to acknowledge the following individuals. Judge Anne Marie Jolly, Administrative Judge of the New York City Family Court. Judge Gilbert Taylor, Supervising Judge of the Queens Family Court. Kelsey Brow, Director of the Rufus King Manor. Allison Morey, Acting Director of the Historical Society. Justice Cassandra Johnson. Justice Frederick Sampson. Judge Soma Saeed. Dean Jelani Jefferson Exum, Dean of St. John's Law School. Zenith Taylor. Keisha Kearse. Bryn Reynolds Seymour, Detective D'Angelo Jones, and Detective D'Angelo Jones. Thank you, everyone. Thank you for attending on behalf of the Historical Society. It's been a pleasure, and please join us at the Rufus King Manor for the reception. Thank you again.